What happened in this exchange matters because it goes straight to the heart of whether the Justice Department still works for the rule of law or whether it's being managed around it. A longtime DOJ attorney has filed a whistleblower complaint alleging he was punished after refusing to sign an appeal brief that he believed was unsupported by the facts in the law. That allegation alone should make every American sit up. If career attorneys feel pressured to put false or legally unsupported claims in front of courts, the integrity of prosecutions and the courts themselves is at risk.
Madam Attorney General, yesterday, Erez Ruveni filed a whistleblower complaint against the Department of Justice. As I think you know, he was a 15-year veteran of the Department of Justice. He received commendations during the first Trump administration for all his work at DOJ, but he filed a detailed account of his recent experience at the Department of Justice, saying that prior to his determination, that he was terminated after he refused to sign an appeal brief that was unsupported by evidence or the law. And he says, "I didn't sign up to lie." In response to his termination, you made a statement on Fox News a little while ago saying, "At my direction, every Department of Justice attorney is required to zealously advocate on behalf of the United States, and that any attorney who fails to abide by this direction will face consequences." So, General Bondi, I guess the direct question is, he says he was fired because he didn't want to make an untruthful statement to a court of law. I have two questions. Number one, I assume you agree that zealous advocacy does not mean telling untruths to courts of law. And second, if that's not the case, what do you mean by saying he was not a zealous advocate?
Senator Van Hollen, this is all pending litigation, as you're well aware, and the timing of it, I can't discuss pending litigation. This is a whistleblower lawsuit pending within my office, but I will say the timing of it I find suspect, as he takes hits at Emil Bovee, who is one of the best human beings I know, one of the smartest, brilliant men I know, who will soon become a federal judge. And his hearing happens to be today, and I find the irony of the timing of it pretty remarkable, the lawsuit. But this had to do with attorney-client privilege information that was disclosed. I can't talk about the substance, but what I will tell you, and you have obviously my word, any zealous advocacy means to be done ethically and honestly, always. And that's what I mean by zealous advocacy. He also accused Emil Bovee of things that Todd Blanche, who is one of the best human beings I also know, my deputy attorney general, was in the room and said did not happen. But again, I wish I could get into greater detail. I can't because it's pending. But I stand by Emil Bovee and I stand by Todd Blanche every day, and I always will.
Well, Madam Attorney General, I will say that his account seems to have lots of information. So as you say, this will obviously be something that's litigated or reviewed through due process procedures. But I have to say that it's very, very disturbing. We've also heard from others in other departments who are responsible for implementing the laws of the United States that they feel uncomfortable about having been asked to do things that they thought were unethical. Let me go on to some of the budget questions, and I really want to follow up on my colleagues, Senator Moran and Senator Collins. But the DOJ grant funding is being sort of cut back on two fronts. One, in April, the department terminated hundreds of grant awards, notifying grantees that their current grant funds were gone, effective immediately. That included, law enforcement training grants, technical assistance awards, some dating back to fiscal year, I think, 2017. So question number one is, are you going to be releasing those funds? The second concern regarding grants has to do with the monies that were appropriated in this fiscal year, in March, and my understanding is that DOJ is withholding an overwhelming number of notices of funding opportunities, NOFOs, meaning that grantees who rely on these grants, including many who provide services to victims of crimes are literally, in some cases, running out of money. For example, the department's biggest grant-making component, the Office of Justice Programs, has only posted one notice for fiscal year 25, no phone notice. So if you could answer the question with respect to both those pieces.
Sure, and that's a very valid question, Senator. The notices will be going out in coming weeks about the grants. And we did cut grants by 6%, and I'm here to tell every senator, if we did cut a grant that you care about that is specific to your state, please contact me. I've turned on grants that were cut off. So please, if that happens, there's an appeal process, but you can pick up the phone and you can call me, and I would be more than happy to look at that. I never want to take away a grant that is actually helping Americans, helping victims, helping law enforcement, and we're looking at it on a case-by-case basis, and many of those are being appealed already, but you have my word, we will look at all of those, absolutely.
Thank you. And in terms of the other piece of the question, when the notices for information will go out, because the fiscal year obviously is, running out, and we are hearing from lots of entities that are waiting for those notices so they can apply for the grant funding.
Yeah, yes, Senator. The notice of funding is consistent with our priorities, and they're finalizing it right now. It will be going out very shortly.
Very shortly. All right. Thank you.
It'll be posted on a rolling basis, too, I believe.
Okay. If you could just keep us posted on that. And I would appreciate it, Madam Attorney General, if you could have your team or respond to a letter that about 30 senators wrote to you on this topic of the prior fiscal year funds that were frozen.
I will make sure they look at that letter. I think we've received probably thousands of letters.
You've gotten lots of letters. But we really do need, in order to do our job, to get responses. Thank you, Mr. Chairman.
Pam Bondi's answer, that she can't discuss pending litigation, that the timing is suspect, and that zealous advocacy must be ethical, doesn't reassure. Saying you expect zealous advocacy to be honest is not the same as explaining why a veteran prosecutor would feel forced to sign something he believed was false. It also doesn't address the larger concern, whether political priorities are crowding out legal judgment inside the department. When the leadership's first move is to defend people in the inner circle and to call the whistleblower's timing ironic, it looks less like faith in due process and more like loyalty protection. The consequences of that kind of culture are immediate and concrete. Career attorneys raise concerns precisely because they have seen the small compromises that turn into larger distortions, inflated legal theories, weakened evidence standards, and briefs that stretch the law to fit political goals. That doesn't just harm abstract notions of integrity, it harms real cases and real people. Evidence that would otherwise be vetted might be presented in ways that can't withstand scrutiny. Victims waiting for justice may see cases collapse, and the credibility of convictions can be challenged on appeal because defense counsel can point to internal political pressure. Van Hollen also pressed Bondi on another, equally urgent issue, the abrupt termination and withholding of hundreds of DOJ grants. These aren't line items in an accounting spreadsheet, many are lifelines. Grants fund forensic exams for sexual assault victims, counseling and shelter for survivors of domestic violence, drug task forces that keep dangerous drugs off our streets, and training that helps local police investigate complex crimes. When grants are cut with little notice, shelters scramble, prosecutors lose resources, and investigations stall. The people who suffer first are the vulnerable: children, assault survivors, and communities that depend on coordinated services. Bondi's promise that notices and funds will be coming out very shortly and that she'll personally review appeals sounds like a patch. When officials respond with hand-waving, "Call me, I'll look into it," that's not accountability. What communities need is a clear, public timeline, a restoration of funding where cuts were made arbitrarily, and protections so that grantees who relied on multi-year commitments aren't left in the lurch. Congress and the department owe those organizations a firm plan. When will each funding stream be restored? How will emergency bridge funding be provided where needed? And who is held accountable for the harm caused by sudden freezes? There's also an ethical footprint to the whistleblower claim that can't be ignored. Whistleblowers in the Justice Department are often the last internal line of defense against abuses of power. They raise red flags when they see directives that appear to bend the law for political ends. If whistleblowers are fired, marginalized, or publicly discredited for doing that duty, the effect is chilling. Other attorneys will keep quiet rather than risk their careers. That creates an environment where bad practices can metastasize. For viewers trying to make sense of it, there are 3 practical takeaways. First, this is not a technical procedural squabble. It's about whether DOJ will preserve the professional standards that make our justice system credible. Second, the grant cuts are not abstract fiscal housekeeping. They have immediate human consequences that demand a public, auditable fix. Third, whistleblower protections aren't niceties. They are necessary guardrails to prevent politicized lawyering. If you want to take action right now, call or email your senators and demand a thorough, nonpartisan review. Ask them to press DOJ publicly for a clear timeline on the suspended grants and to insist on emergency relief for the programs that serve victims and public safety. Tell your senators you support robust protections and confidential channels for DOJ whistleblowers, and that any allegation of being asked to present false legal claims must be fully investigated by an independent inspector general. Amplify the story in your local community. Survivor services and small grantee organizations need public pressure to get immediate fixes. This is about more than one complaint or one round of funding decisions. It's about whether the institutions charged with upholding the law will be defended when they are threatened from within. If you believe in accountability, in protecting victims, and in an independent Justice Department that follows the law rather than political expediency, this is the kind of oversight you should follow and demand more of. If you'd like, I can draft a short, ready-to-send email your senator can use to demand answers on the grants and whistleblower protections. Tell me whether you want a brief 2-sentence version for a call or a longer template for email, and I'll write it now.